Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello, and welcome to our Curious Amalgam. I'm Jana Seidl, and the title of today's episode is What About Small Tech? Democratizing Employment Data. Employment data is a critical component of the financial ecosystem. It's required documentation if you want to rent or buy a home, purchase a car, apply for a new job, or get a loan. As digital technology is transforming the manner in which payroll information is collected and leveraged, we're faced with important questions, the answers to which will shape the framework going forward. Those questions include who owns this data, what does this mean for user access as well as data portability and interoperability, and how can companies bring innovative products to market and deliver more meaningful protection and security than exists in the market now. In this episode, we speak with Nick Lawson about all things employment data, including the current framework, what's happening with the Consumer Financial Protection Bureau's rulemaking on personal financial data rights, and predictions for what might be ahead. Joining me today is my co-host, Elyse Dorsey. Hi, Elyse.
Hey, Jana.
Would you like to introduce Nick?
I would love to. So today we have Nick Lawson, who is the General Counsel of Argyle. Argyle is a data portability and payroll connectivity solutions provider. In addition to his in-house role, to date, Nick has spent some time in big law where he focused on technology transactions and intellectual property issues arising from mergers, acquisitions, divestitures, and financing. Nick, thanks so much for joining us today.
Thanks so much for having me. I appreciate it.
This is a really fun one for me, Nick. I feel like we're back in property class for our first year of law school.
I know. It's definitely a throwback for me as well.
As long as we don't have to talk about the rule against perpetuities, I'm happy to be here.
I think we're safe today.
Awesome. So Nick, we thought we'd start, with kind of laying some foundation for us here. So can you kind of give us a 30,000 foot overview of what payroll data is, what that encompasses, and especially for non-standard workers, what it means?
Absolutely. So you kind of got into it a little bit in the intro to the podcast, but payroll data in the most traditional sense is anything that might show up on your pay stub. So that includes things like gross income, net income, deductions, bonuses, withholdings, who your employer is, what your pay rate is, what your pay period is, the number of hours that you work, et cetera, et cetera. This data really is top of waterfall in the modern economy in a way that I think is perhaps a bit underappreciated. It's some of the most substantive data in connection with obtaining a mortgage or a car loan, or if you need to lease an apartment. Think about any time in your life when you've been asked to produce a pay stub to verify your income or employment. So the data set has gotten, in maybe the last 15 years, a bit more rich and a bit more complicated with the rise of kind of widespread gig work. Now, of course, it's always been the case that independent contractor income has existed, and some people have been 1099 contractors for much of their career. But right now, you have an economic environment where, call it up to 10 to 15% of the workforce at some point in the calendar year might be engaged in gig work and might be receiving a substantial portion of their income from gig service providers. And so the underwriting models that have existed for the last half century don't necessarily and haven't necessarily been written in such a way to sort of fully internalize the nature of that data and how to underwrite and loan and lease based on kind of work that's not traditional W-2 income. And so in payroll data from our perspective includes not just the things that would appear on a pay stub, but if you're a gig worker, all of the individual pieces of data that in fact can give a potential lender, employer, lessor insight or reasonable expectations as to how much money you might generate over a given period of time.
Thank you for that really helpful overview. I think that really kind of gets us all on the same page. So we know that Argyle operates in the data portability and payroll connectivity space. Can you tell us a little bit about what it is that Argyle does and what you all focus on?
Yeah, so there's a lot of different ways to sort of describe or frame what we are and what we do. Sort of one of them is a data network, right? Where what we have is we have software that's interoperable with payroll platforms and with gig service providers. And let's say that you're a consumer, right? What might happen is if you're applying for a mortgage, you might be in your mobile banking application. And then as part of that mobile banking application and as part of the loan application in that mobile banking app experience, your bank might say, thank you for applying for this mortgage. We need to verify your income and employment. We've partnered with Argyle to do so. Then what will happen is a little widget or a little in-frame wire app will pop up. And what you'll do is the consumer will be able to use Argyle's software as a service platform to log into their payroll or gig service provider. The software as a service platform will then retrieve, standardize, and deliver the data that sits inside of that payroll platform into the mobile banking application in connection with that mortgage or personal loan or what have you. So in that sense, we're a data network. We move data from point A to point B on a fully consumer permission basis. The other way to frame it right is payroll connectivity. We connect to people's payroll accounts and we provide data portability services so that an individual can effectively move, retrieve, and deliver and leverage their own data for their own benefit.
Thanks. That's, again, helpful to us in kind of understanding what it is you do. And as you were kind of talking through that, I think one thing that came up is that you're subject to some interesting regulatory intersections, right? Both the FTC and the Consumer Financial Protection Bureau regulate the provision of financial services from a consumer protection perspective. And so can you talk about some of those dynamics and how a company like Argyle that, sits in kind of a new space at the intersection of these various regulations, how you kind of navigate that field?
Absolutely. It's super, super interesting, right? And one of the things that a lot of people don't realize is that not only does Argyle provide services to financial institutions, by dint of the nature of the data processing that we engage in, we are ourselves a financial institution. And so we are subject directly to all of the same requirements that your banks are subject to under the Gramm-Leach-Bliley Act, so the Safeguards Rule and the Privacy Rule. And so what that means, right, is that when I think about engaging with the FTC and the CFPB, I think about engaging with them both as my regulator to kind of educate them about the nature of the technology, its consumer protective benefits, its privacy protective benefits. And then in addition, right, we're a disruptive entrant in what has been a fairly static market for, call it, the last 50 or so years. And so one of the other things that we sort of view our role as, where it's appropriate, when it's appropriate, is to help the regulators understand kind of how some of the incumbent practices are maybe not as consumer protective as they could be, and maybe don't necessarily comport with where certainly I believe and where I believe that my company believes the universe is moving on a data privacy and a data security front.
Yeah, so that's really interesting in terms of, I know you talked about educating the agencies, for example, especially from your perspective. And I know that the CFPB is currently undergoing rulemaking, right? And I would like to talk a little bit more about that and the concept of open banking. So the rulemaking right now, my understanding is that it will implement Section 1033 of the Dodd-Frank Wall Street Reform and Consumer Protection Act, and that the CFPB was actually called on specifically to do that rulemaking in President Biden's executive order on competition in July 2021. So can you first explain what is open banking?
Absolutely. So open banking is kind of a paradigm shift in the nature of the relationship between a consumer, their financial institution, and the data that the financial institution has been, call it, the steward or custodian of for the last, call it, 50 years or 100 years. So most commonly, that's sort of transaction level data. Every single transaction that hits your account, money in, money out, every single time your direct deposit hits. And so what you kind of saw about 10 years ago, and when they passed Dodd-Frank in 2009, was you saw an industry kind of arise that had never existed before. And I'm going to mention some names that the listeners might be familiar with, kind of prominently Plaid, Yodlee, Finicity, all of these people that essentially got into the business of moving data from a bank account, housed inside of, you go log into your Bank of America and you see all your transactions, into kind of the classic use case was the financial services application. So like Copilot and Mint, things that help people have a better understanding into what they're spending, increase their financial literacy, helps them have visibility and save. All of those kind of good things started in 2009. And it is just now the case that the CFPB is actually formalizing the rules around that requirement in the Dodd-Frank Act. Dodd-Frank, they had a lot to do. It makes sense that it took them a little while. And so one of the core tenets of open banking, right, is that while this information had previously been siloed in individual financial institutions, and it wasn't really clear necessarily whose data it was precisely, the open banking paradigm makes it the case that consumers have the right to require their financial institution to share their data with third parties that are not related to the bank in ways that benefit the consumer. And so the rulemaking that's going on right now is the CFPB getting really, really in the weeds in a good way and really specific about what the requirements of that sharing look like. And so to me, that sort of has two large kind of buckets. The first is sort of what authentication mechanism do we think a bank can implement in order to comply with the rule? And by authentication mechanism, we just mean, how do we know that it's the consumer who's actually saying, go deliver my data, right? And there's obviously fraud risk endemic. And then the second bucket is, okay, once we've got authentication, what are the sanctioned methods for data access and retrieval and delivery, right? And so those are all sort of technical questions that can be they're philosophical and technical questions to a certain extent. So that's what the CFPB is engaged in right now, and it's really laudable, and I'm really excited to see what they come up with, because this presents a massive opportunity for consumers and a lot of opportunity to encourage competition, and it'll also introduce a fair amount of certainty into the market around what the actual requirements of this law are, with actually a really laudable and appropriate purpose.
Yeah, that sounds like a lot of really exciting developments in the space, which, as you noted, has been pretty stagnant for a long time up until recently. And I think it's part of a broader conversation that's been happening in the ethos about consumer data, who it really belongs to, how consumers can access it. And so one question I have as someone whose financial literacy is maybe not so high is, do you have an idea yet of how this is going to translate to consumers and how, someone like me might be able to kind of navigate that and figure out what data is available and how I can best use it following the CFPB rulemaking?
That's a really interesting question. And until we have a proposed rule, I can't really speak with much by way of expectations. I think that the CFPB in its SBREFA outline, and the SBREFA outline was going on 100 pages, asked a lot of really, really interesting and really targeted questions. And I know that we provided some responses to those, and I know that a lot of other stakeholders provided some responses to those. Until there's a proposed rule, it's hard to really know precisely how it's going to impact the market. That said, I think there are a couple top-level takeaways. First, the Bureau is really interested in making sure that data is shared in a secure way, and is really, really honed in on kind of methods of authentication and also methods of retrieval and collection and delivery that are going to meet consumers' expectations when they use the service. So I think that what I would expect to see coming out of the SBREFA process and into the actual proposed rule is going to be a rule that hopefully sets out some fairly strong expectations around security and privacy with respect to the use of the data. The next thing that I think, and this is going to be an interesting balancing act, right? Because on the one hand, the more secure you make something, the more lockdown you make something, the harder it becomes for people, the more rigid the standard becomes. And so I think it's going to be really interesting to see the CFPB do what it can do to try to strike the right balance between being, call it, technology agnostic and flexible on the one hand, and on the other hand, making sure that they're performing their function, which is a consumer protective function around the privacy and the security of the information. I also hope, right, that they embrace a standard that doesn't necessarily entrench any existing market players. I think that what the point of the rule should be is to create a level playing field for all people that have the ability and the interest in attempting to deliver innovative financial products and services to consumers. And I'm really excited to see what they come up with.
Yeah, what's really remarkable out of the conversation so far that kind of stands out to me is that this is really all about defining users' rights, users' ability to ensure that their data remains secure, given the digitization of everything, wanting to ensure it's a level playing field. And I know that Argyle also submitted a letter to the FTC late last year, encouraging that agency to kind of investigate the industry as a whole, right? The payroll data broker industry. And You all said that the ubiquitous buying and selling of employment and payroll data harm both consumers and competitions. Can you expand on that a little bit and explain why that is?
Yeah, absolutely. So without naming names for incumbent players, right? The current market for income and employment verification is dominated by, I call it two to three household names. And that market grew up in a world where it was very expensive and very, very difficult to move data around. And so in order to verify income and employment, it would make some sense that large players would have an inherent advantage in assembling and packaging the data and then turning around and selling it. That said, that's a 1970s paradigm, right? You wouldn't build the system that way today, given what modern information technology can actually provide. And in addition, I think we believe that fundamentally the data belongs to the consumer to which it relates. And a market that's built around buying and selling a consumer's information that's fairly intimate in a lot of ways, around how much money they make and who they work for and how many hours they work and where they work. All of that information rightly belongs to the consumer, and they should be able to control who it gets directed to and when it gets directed to and where it gets directed. And so what we have today, right, is a market that kind of got where it got by dint of the technology that was available at the time. But where we are today is that data is being monetized without consumer consent. And if you've ever applied for a mortgage or you've applied for a loan and that loan has a fee, that's the consumer essentially paying to move their own data. And those prices are often quite exorbitant, sometimes $70, $80 plus to verify income or employment. And I have in mind in particular the mortgage use case. So in that sense, it harms consumers because their data is exploited and monetized without their consent. When a broker performs that type of verification of income or employment, there isn't a natural inflection point for the consumer to verify the data is accurate, which is what you're able to do when you're able to log into your payroll account, right? And what Argyle software as a service platform does, it essentially logs into the best source of truth and moves the data from the best source of truth that is the most up-to-date and current. And so there, right, what you're doing is you're introducing a situation where the consumer does not have full visibility into the data as it moves, and then is paying a very, very high price in connection with the product. And we don't think of that as being terribly consumer friendly. It harms competition in the following way, right? Which is that anytime there are large and entrenched players in a market, those entrenched players naturally attempt to defend monopoly pricing power. And I think if you look at any of the more recent investor calls on some of the existing players, they're saying things like, we can increase prices much faster than inflation. That type of pricing power is inherently, from my perspective, indicative of somebody who has a ton of ability to extract higher prices from the market than the market would otherwise bear. And then also a highly concentrated market tends not to be a terribly innovative market. And so it could very well have been the case that those incumbent players might have tried to build the type of solution that they've tried to, that Argyle and some of our peers have built. They haven't done that. And so what you end up with is a situation where the technology has not moved, the price remains high, and it's difficult for new entrants to enter the market. And so I think that's from my perspective how it harms consumers through higher prices and how it harms competition.
Yeah, that makes a lot of sense. And so one thing that had caught my attention recently was some developments in how companies are paying out gig workers or, contract workers. And so I think, the traditional sense in which folks have been paid is often on a monthly or biweekly basis, right? And it's been pretty, again, kind of static, not a lot of developments in terms of how employees are actually paid out. But the gig economy, as I understand, has kind of been changing that, where, it's been causing some competition and incentivizing some companies to start trying to pay out workers at the end of shifts, so at irregular intervals. Is that something you're seeing, and is that kind of affecting employment data, how it's stored, and is that kind of factoring into your analysis at all?
So absolutely. So I think what you're talking about are programs like earned wage access programs, where the individual, instead of being paid biweekly or monthly, can actually be paid on a daily basis, right? And if there's a way to think about you being paid biweekly or monthly as essentially you loaning your labor to whoever you're working for, And then they get the benefit of the time value of that money, and then you're paid in some periodicity. And so generally speaking, I think it's better for consumers to get access to the wages resulting from their labor sooner rather than later. One of the ways that you can provide that product, or one of the things that you need in order to provide that product or service, is real-time visibility into how much someone has worked and their expected earnings for that period. And that's something that really hasn't been possible until a company like Argyle has existed, where we have the ability to maintain a periodic connection to the actual workforce management platform. And so an earned wage access provider can have a reasonable expectation that if a gig worker worked X amount of hours in a certain day, they will be able to be advanced that amount of money from the EWA provider. Or if you're a shift worker, the exact same thing applies. If you're working at a large retailer, you're a part-time worker. All of those data points are necessary in order to know how much that individual should be paid for the period. And they shouldn't have to wait 2 weeks or a month to get paid by that particular individual. And we think of that as fundamentally consumer friendly.
Yeah, that's actually really fascinating and really valuable for everyone involved in a sense. And so it's interesting to hear you talk about the changes that have been coming to this industry and kind of where things have been going given the new tools, the new technology that's available. And I think I'm going to ask you to maybe give us a couple of predictions of what you think might continue to happen and where this space might be going in the next 5 years, or where you kind of would hope it would go, right? Knowing that there are some uncertainties involved.
Yeah, so fundamentally, we hope it goes in a way that continues to recognize and vindicate consumers' rights in their own payroll data. I think you see with the more recent revisions to the CCPA and with Texas passing data privacy laws, you're going to continue to see kind of in American culture a fundamental respect for individual personal data that's maybe been a little bit lagging as compared to Europe, which thinks about these issues in a somewhat different way than we have traditionally thought about them. I think our hope here is that sort of the recognition around open banking and the importance for consumers to be able to control their transaction level data should actually also extend to a broader swath, namely payroll data, right? Payroll data truly sits kind of at the top of the financial waterfall. It's an incredible indicator for people's ability to repay. It's essential. You have to supply it in connection with almost any major financial product or service that you obtain. And so we hope that the regulators continue to sort of evolve their understanding and expand their view on what counts as consumer financial information, and continue to take steps towards recognizing that consumers should have the right to share that information with who they see fit, and to share it in ways that are efficient and enable that consumer to effectively obtain products or services they need to make their lives better. We hope adoption of solutions like Argyle's is rapid. Obviously, we're a Series B company and we're scaling up and we're excited. I think what I personally expect to see is kind of gradual and then rapid adoption, which is sort of what you saw in the banking aggregator space, where for the first couple of years, it's sort of proved the use case, proved the value of the data, proved that it actually improves people's lives and that you can provide the service in a way that respects people's privacy and provides a high level of security. And then once that's the case, right, I think what you see is widespread adoption. That's largely what I expect to see in this space, but I sincerely hope it's the case that the experience with the banking aggregators makes the absorption time less in this instance, in part because the data is so important for consumer well-being. And so I think we're going to have kind of a similar adoption curve, hopefully on a shorter time span.
Okay, great. Well, yeah, thanks, Nick, so much again for joining us. This was super interesting, and it sounds like a lot of really exciting developments, hopefully, over the next few years. And we'll probably be seeing lots more of these issues in consumer protection and maybe even on the antitrust side of the house. Before we let you go, I have a couple questions to help our guests get to know you a little bit better. And the first one is, what advice do you have for young lawyers?
So the biggest piece of advice that I have for young lawyers is, I think, somewhat obvious, right? But it's learn as much as you can. You come out of law school with more of a skill set than a knowledge base. And it takes a lot of exposure to a lot of stuff to kind of hone that. And so just continue to be as much of a sponge as possible. And the second thing that I want you to know kind of dovetails with the first thing, which is that careers in law tend not to be super linear. I mean, mine certainly hasn't been linear. I started intending to be a trademark associate, and then I kind of lurched into IP transactions, and I lurched from IP transactions into in-house roles where I'm now kind of call it a light financial services regulatory attorney plus an IP attorney. I've found that journey super rewarding and super interesting, and I've never been bored. And so try not to chart your career with sort of a single-mindedness. Be open to learning stuff and be open to riding the wave where it takes you. And I know that's certainly been true for me.
Yeah, I've actually really enjoyed watching you kind of make that move. And it's been really, really fun to kind of have these conversations with you. And so I think that's a great piece of advice. Now, I do have to ask you the second question. Can you tell us something interesting about yourself that we wouldn't know if we only knew you professionally?
Absolutely. I was a beekeeper between the ages of 12 and 18. And it is my father's eternal disappointment that I am no longer a beekeeper. He continues to ask me whether or not I'm willing to put beehives on the roof of our house here in Washington, D.C. And I don't want to be hated by my neighbors. So the answer to that is a general no. But yeah, so I spent a lot of high school, and my father was a beekeeper as well. So it was something that he and I used to do together to bond. And I got to tell you, they're wonderful little insects. They're domesticated animals. They have a really nice vibe to them. You kind of have to, in order to interact with them, you have to sort of zen out. If you're frightened, if you're stressed out, they sense it and they react. And so it's interacting with beehives is a real exercise in mindfulness.
Well, thanks for that fun fact pick. So I think it's a really cool one, a really apt one. So Nick, thanks again so much for joining us today. That was a really illuminating conversation. I know I learned something. I hope our listeners did as well. And so thanks everyone for listening, and we hope you tune in next week.
Thank you for listening to this week's episode of our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.